Every day in 60 courts throughout the country, roughly 400 immigration judges sit to decide the fate of thousands of people. Walking by a court, you probably wouldn't even know what is going on inside. Courtrooms can be located from in immigration and customs enforcement detention facilities to in federal courthouses or in leased commercial office spaces. They rule on whether a person is a U.S. citizen, whether a non-citizen can qualify for a status that allows him or her to remain in this country, or whether a person has violated our laws and must be forced to leave. Their decisions may cause the separation of parents and children or husband and wives. Because the law gives judges no discretion to allow someone to remain in our country based solely on hardship or humanitarian reasons. And at times the decisions can amount to a death sentence, such as when they deny an application for asylum because the law does not protect all those who find themselves in harm's way back home. Asylum seekers tend to come from the Central American countries known as the Northern Triangle, El Salvador, Guatemala, and Honduras, and they make up a growing share of the backlog. Altogether, asylum seekers accounted for about half of new immigration cases last year at a record 159,590 cases. The Trump administration has viewed this increase with alarm and has said that migrants are abusing the system. As part of broader efforts to tighten immigration policy, officials have sought to narrow the path to asylum and limited processing of these cases at the border. The White House's most recent proposal to end the standoff over border security and to reopen the government included several provisions aimed at restricting asylum claims. Immigration courts should be put under the judicial branch to avoid the president's administration's views causing the backlog of courts. According to Denise Liu and Derek Watkins of the New York Times, the wait time for hearings and decisions have grown. The average case now takes 578 days to complete. About 1 in every 40 cases is criminal or related to national security or terrorism. The number of asylum and other immigration-related cases facing U.S. judges has skyrocketed in the past 2 decades, creating a backlog of more than 800,000 active cases before the shutdown began. The backlog is made up of all kinds of immigration cases. Most involve people waiting for a judge to determine whether they should be allowed to stay in the United States or should be deported. The rest are civil immigration cases. They can include migrants arrested for crossing the border illegally, people who overstayed their visas, and many asylum seekers. During the government shutdown, dozens of immigration courts remained shuttered across the country, and tens of thousands of hearings were canceled. This more than likely added to the backlog of cases. After the shutdown began, court proceedings stopped for anyone who is not detained by U.S. authorities. Cases for detained immigrants could continue under the Justice Department's shutdown plan. Many people, particularly those traveling with children, would not necessarily be detained for long periods of time unless there is evidence of other criminal activity. The shutdown also creates a paperwork backlog, as courts for non-detained cases are not open to receive key documents from lawyers. That includes case documents to help asylum applicants prove their right to stay in the U.S. According to Dana Leigh Marks, she's been sitting as an immigration judge in San Francisco since 1987 and is the president of the National Association of Immigration Judges. She claims the volume of the work of court cases can be overwhelming to judges. Some of the judges carry caseloads of 5,000 cases or more, usually with limited support staff. Because they work for the Justice Department, they are directed on how to arrange their dockets and micromanaged about how much time they spend on cases. Beginning in October of last year, judges were ordered to complete 700 cases each year or risk a less than satisfactory performance evaluation, which can cost a judge his or her job. This is not how a court should be run. According to Attorney General William P. Barr, he told Congress this past week that he's hoping to boost the number of judges in courtrooms from around 425 to 535 over the next few years, and for a commensurate boost in lawyers and clerks. The court system is very disorganized, which frustrates judges. Judges need to be independent judges and not be monitored and rated like assembly line workers. They must be allowed to use their expertise to decide cases without interference. The current structure detracts from due process and makes people doubt the fairness of the courts they preside over. Judges need skilled, experienced, neutral managers who understand how to run a court and make transparency, independence, and public access paramount, not administrators who want to keep the trains running on time above all else. Reporters covering immigration enforcement, drug trafficking, and national security. They claim since Trump took office, the backlog has swelled by more than 200,000 cases. The president has grown so frustrated that he has been floating the idea of doing away with the U.S. immigration courts, which are part of the Justice Department, not the judicial branch. "We don't need a court system," he told Fox Business Network anchor Maria Bartiromo this week. "We have a court system that has 900,000 cases behind it. In other words, they have a court which needs to hear 900,000 cases. How ridiculous is this?" He added, "What we need is new laws that don't allow this, so when somebody comes in, we say, 'Sorry, you got to go out.'" Trump on Monday, April 29, 2019, ordered his administration to draft new regulations that call for courts to tighten the existing requirement to adjudicate asylum cases within 180 days. The measures seek to deter new asylum requests by imposing fees on applicants and limiting their ability to qualify for work permits while waiting for their claims to be heard. Trump hopes that faster scrutiny of asylum claims and perhaps a higher bar for establishing credible fear of returning to their home countries will turn more people away, especially those he thinks are gaming the system. Immigration courts becoming under the judicial branch is a need for all immigrants across the country, and it needs to be done now. It would free our courts from the political influences of both the Justice and Homeland Security departments and the political whims of each new administration. It would allow a reliable funding stream from Congress to ensure we have the resources needed to address our burgeoning caseload in a timely manner. It would mean that neutral judges would use their skills to make the rules and assure a level playing field for all. An independent immigration court will be an efficient and effective court that provides an example to the world of the superiority of the American justice system. We can and must fix this fatal flaw now. In the 2020 election, some of us will be 18. That is the year we can use our opinion and vote for the candidate who we think is the best, and vote for representatives and senators and presidential candidates who have the views to bring the immigration courts forward and improve them. In 2020, if you are not 18 in the meantime, even today, we should all start educating ourselves on candidates' views towards immigration, because potentially our vote could be helping to educate a friend who could change the lives of many immigrants.